The United States Supreme Court is about to weigh in on a major case centered on Second Amendment rights, specifically aimed at challenging federal authority and restoring the ability of individual states and their officials to establish their own firearm policies. What we're looking at here is a serious test of Second Amendment protections, this one coming straight out of Missouri. The state's legislature passed what's called the Second Amendment Preservation Act, or SAPA. It's already made its way through a few legal hurdles and is now heading back to the nation's highest court for conference at the start of the new judicial term. Not long ago, the court issued a ruling 8 justices to 1 refusing to pause enforcement, which would have kept Missouri's SAPA in effect. Even so, the justices are circling back to decide whether they'll take the case up formally. The Trump-era Department of Justice finally submitted a reply after dragging its feet for months. In that filing, they doubled down on the claim that parts of Missouri's SAPA are unconstitutional and insisted that the court should pass on reviewing it. Interestingly, they also offered a trade-off, saying that if the court declines to hear the case, the federal government would voluntarily drop a few minor lower court wins to allow parts of SAPA to continue. Missouri fired back by pointing to that very offer as evidence that the case needs a full review. Their argument is simple. If the federal government is willing to give up small victories just to avoid scrutiny at the Supreme Court level, then the court should absolutely step in. The justices are scheduled to discuss the case during their conference on September 29th, and that's when we'll see whether this turns into one of the landmark Second Amendment decisions of the next term. For those not familiar with the situation, this lawsuit centers around Missouri's Second Amendment Preservation Act, originally signed into law back in 2021. This piece of legislation outlines Missouri's own interpretation of the Second Amendment and limits the ways in which the state and its employees can assist federal agencies in enforcing gun control laws that Missouri considers to be unconstitutional. In effect, it bars state law enforcement officers and government officials from aiding federal agents with the enforcement of firearm regulations that go against Missouri's stance on the right to bear arms. One of the most unique elements of the law is the civil enforcement mechanism. It gives private citizens the ability to take legal action against any Missouri official who cooperates with federal authorities in enforcing those contested firearm laws. That puts real power into the hands of individual Missourians, holding their state government accountable to the people when it comes to Second Amendment rights. When this law was first challenged, a federal district court sided with the Biden administration, striking down the statute completely. Missouri appealed the ruling to the 8th Circuit Court of Appeals and also requested a temporary hold on the lower court's decision. Eventually, the state asked the United States Supreme Court for an emergency ruling to keep the law in place during the legal battle. But the High Court issued an 8-1 decision denying that emergency request, with Justice Clarence Thomas being the lone vote in favor of granting the stay. After that, the case moved forward in the 8th Circuit, where the court fast-tracked oral arguments and once again ruled in favor of the federal government, striking down Missouri's Second Amendment Preservation Act in full. Now, Missouri has formally submitted its petition for review to the Supreme Court, asking the justices to consider the full merits of the case. One of the central arguments Missouri makes is that the 8th Circuit effectively acknowledged the legal structure and mechanisms of the law as being sound, but invalidated it anyway, due to its Second Amendment focus. Missouri contends that the appellate court contradicted established precedent by allowing state officials to be sued just for following their own state law, as if their decision not to act in favor of federal enforcement somehow Although the Biden administration originally challenged Missouri's Second Amendment Preservation Act, the legal battle is now in the hands of the Trump administration. In their recent filing, The Trump-era Department of Justice argues that Missouri's law is partially invalid, agreeing in part with the earlier lower court decision. However, they also claim that if the Supreme Court chooses not to take up the case, the federal government plans to walk back portions of the ruling once the matter is remanded back to the district court. The Department of Justice under President Trump wrote in its brief that, following the change in administration, the United States has decided it no longer wishes to challenge those provisions in its pre-enforcement posture. They go on to express concern that the current judgment reaches too far and blocks applications of the law that simply amount to non-enforcement of federal regulations, something the anti-commandeering doctrine clearly protects. The DOJ suggests that if the case returns to district court, they will not oppose a motion under Rule 60B of the Federal Rules of Civil Procedure to reduce the scope of the injunction. In response, Missouri fired back, arguing that even the federal government now admits the Eighth Circuit overstepped. According to the state's filing, the law in question isn't meaningfully different from similar laws already on the books in other states' laws that prevent state resources from being used to help enforce federal gun control measures. Missouri's legal team questioned the logic of the DOJ's position, writing, "It is difficult to understand why the government would ask this court to deny relief if it now concedes the district court went too far. What does it expect the lower court to do with a Rule 60 motion if the Eighth Circuit decision is still in place?" Missouri argues that the district court, bound by that appellate ruling, won't have the authority to fix what the DOJ itself now admits went too far. For that reason, they're urging the justices to not just take the case, but to immediately reverse the Eighth Circuit's ruling. There's a real possibility the Supreme Court decides not to get involved, especially since the Trump DOJ appears to be offering an off-ramp by agreeing to scale back the earlier judgment. That path could allow the justices to sidestep the issue altogether. But Missouri makes a strong case that unless the Supreme Court intervenes, the precedent from the Eighth Circuit remains intact, and that precedent could block meaningful enforcement of state sovereignty in future conflicts. This pivotal Second Amendment case is scheduled for conference on Friday, September 29th. But the justices could still choose to delay their decision beyond that date. We expect some movement early in the court's next term, and I'll be keeping you updated every step of the way. If you want to support the channel, one of the best things you can do is hit that subscribe button. You can also head over to my site, armedscholar.com, where you can grab a free legal survival guide by dropping your email, check out channel gear, or find some of the best daily deals I've curated to help you save money while supporting your rights. As always, thank you for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was founded by armed scholars, and it'll be preserved by armed scholars.